Hello and welcome, everyone. Hope you're all having a lovely day, and thank you for joining us for this important and timely book discussion. My name is Gayatri, and together with my colleague Svetlana Van Bentham, I'm co-convening the Oxford Transitional Justice Research Group this year. And as some of you may already know, we are an interdisciplinary network of academics and students at Oxford working on issues of transition in societies facing conflict or authoritarian rule. And today we have the absolute pleasure of Judge Kriangsak Kittichaisaree to discuss his crucial upcoming book, The Rohingya Justice and International Law. Now, before I introduce him and our discussants, I'd like to first thank the co-hosts of this event, the Bonavero Institute of Human Rights, and the Program on International Peace and Security at the Oxford Institute for Ethics, Law and Armed Conflict, for their incredible support in the days leading up to this event. And on that note, I will give the floor to Professor Kate O'Regan, Director of the Bonavero Institute of Human Rights, to deliver welcome remarks. Kate.
Thank you very much, Gayatri, and a very warm welcome to all of you who are attending this, and a particularly warm welcome to our panelists. The Bonavero Institute of Human Rights is a relatively new research institute in the Faculty of Law at the University of Oxford. And I'm proud to say that one of our very first research visitors at the Bonavero Institute was our speaker today, Judge Kriangsak Kittichaisaree, who he is now a judge of the International Law of the Sea and has a very distinguished career in international law. And of course, this book that he has written on international law and the Rohingya in Myanmar is an extremely important book. So it's lovely to see you again, Kriangsak, even though it's not in Oxford and we're all spread all over the world, but it's lovely to see you. It's also wonderful to be a co-host to the other panelists here today, Priya Pillai and Stephen Rapp. Thank you very much to the two of you and to Kriangsak for joining us. And thanks to OTJR for kind of inviting us to be one of the co-hosts in this event. And as always, it's a great pleasure to be also co-hosting with the Ethics and Law and Armed Conflict Center at the Blavatnik School. We have done this many times over the years, and they're a kind of great part of the overall team here in Oxford. Thanks very much, Gayatri.
Thank you.
Thank you so much, Kate. Well, without any further delay, let me now introduce our panelists for the day. Judge Kriangsak Kittichaisaree, who authored this important book, is a judge of the International Tribunal for the Law of the Sea. He has previously served in so many different roles, including chairperson of the ILC's working group on the obligation to extradite or prosecute, and chairperson of the working group on the administration of justice at the UN. And has so many publications to his credit, ranging from the themes of international criminal law and human rights law to the law of the sea. We are also joined by two equally incredible panelists. Ambassador Stephen Rapp is currently Senior Visiting Fellow of Practice with the Program on International Peace and Security at ELAC. He is co-leading a project that aims to strengthen global capacity to gather and preserve evidence of criminal responsibility for the most serious human rights violations. And he has previously served as the chief prosecutor of the Special Court for Sierra Leone. The second discussant, Dr. Priya Pillai, is an international lawyer and heads the Asia Justice Coalition Secretariat, a network of organizations focused on justice and accountability in Asia. Dr. Pillai has also worked at various national and international institutions, including the ICTY and the International Federation of Red Cross and Red Crescent Societies headquarters in Geneva. We couldn't have asked for a better panel for today, and I'm eagerly looking forward to hearing from all of you. Just a note to all the attendees, this discussion will be followed by a Q&A, so please feel free to submit any questions through the Q&A button at the bottom of your Zoom screens. That's all from me. Judge Kittichaisaree, the floor is yours. I'll just pull up your slides in a moment.
Thank you very much, Kate and Gayatri. So I'll start by leading you to the many PowerPoint presentation that I have prepared. So who are the so-called Rohingya? According to the International Court of Justice, the Rohingya are the group that self-identifies as the Rohingya group and that claims a long-standing connection to Rakhine state in Myanmar. They are Sunni Muslims claiming to be indigenous to Arakan region, now Rakhine, before its conquest by Burma in the late 18th century. However, the Myanmar government itself does not recognize Rohingya as one of the 135 indigenous ethnic groups, but as Bengalis and illegal immigrants brought in from Bengal, which is now Bangladesh, by British India to expand rice cultivations in Rakhine. In the year 2017, more than 740,000 Rohingya fled the so-called clearance operations by the Myanmar military or the Tatmadaw to Bangladesh. Next. Next, please. The Association of Southeast Asian Nations, or ASEAN, to which Myanmar is a member state, operates on the basis of non-interference in internal affairs of another member state. And there is no regional human rights court or any international mechanism to hear individual human rights complaints. Therefore, Malaysia, which is an ASEAN member state with a majority Muslim population, turned to the Organization of Islamic Cooperation, OIC, which has been actively dealing with Rohingya issues since 2012, leading to the setting up of an ad hoc ministerial committee chaired by the Gambia. Here comes the Gambia in its capacity as the chair of this committee set up by the OIC. The committee is set up to ensure accountability and justice and to mobilize and coordinate international political support for accountability for human rights violations against Rohingya in Myanmar. The next slide will show that the UN Security Council, or UNSC, has been dealing with Rohingya issues since June 2012. However, due to geopolitics in the SC, the best that the SC could achieve was issuing a presidential statement in November 2017 to, among other things, strongly condemn widespread violence in Rakhine since August 2017 and to express serious concern over reported human rights violations in Rakhine, including by the Myanmar security forces against the Rohingya. The next slide will show that the Human Rights Council, or HRC, did much better than the SC by setting up two bodies. The first one is the Independent International Fact-Finding Mission on Myanmar, or IIFMM, which finds sufficient information for the investigation and prosecution of senior Tatmadaw officials for genocide against Rohingya in Rakhine, crime against humanity, and war crimes in Kachin, Rakhine, and Shan State. The other body set up by the HRC is the Independent Investigative Mechanism for Myanmar to collect, consolidate, preserve, and analyze evidence of the most serious crimes and violations of international law in Myanmar since the year 2011, as well as to facilitate and expedite fair and independent criminal proceedings in national, regional, or international courts, and to cooperate closely with any of the SEC prosecutors' future investigations. In sum, up to the end of, say, November 2019, diplomacy had failed, and resorting to litigation became the only viable option for seeking justice for the Rohingya. Let's now look at the next slide, the ICJ. the International Court of Justice. The case in the ICJ concerns Myanmar state responsibility for its alleged violations of the 1948 Genocide Convention. The Gambia asserts that Myanmar violated this convention through acts of genocide against the Rohingya adopted, taken, and condoned by the Myanmar government from around October 2016, which since August 2017 continue on a more massive and wider geographical scale. The Gambia also asserts that it has made this claim known to Myanmar since September 2018, but Myanmar has continued to deny any wrongdoing in this respect. The next slide will tell you that there are two jurisdictional hurdles faced by the Gambia in the ICJ. The first jurisdictional hurdle is that of the legal standing of the Gambia to bring the case against Myanmar in the ICJ. Due to Bangladesh reservation to the Genocide Convention, Bangladesh cannot sue Myanmar in the ICJ without Myanmar's prior consent, which has not been given, thereby leaving the Gambia to act on behalf of the OIC. This hurdle is not difficult to overcome according to my research. According to the ICJ case law, all state parties to the Genocide Convention have a legal interest in the protection of the rights covered by the convention itself. The next slide shows the second jurisdictional hurdles. That is the existence of the dispute between the Gambia and Myanmar as of 11 November 2019, the time and date when the Gambia filed the applications against Myanmar in the ICJ. This hurdle is more difficult for the Gambia than the first one. This is because the contestation of claim between the Gambia and Myanmar was mostly at multilateral diplomatic forums, such as the UN General Assembly. This brings to mind the ICJ judgments of 2016 in the cases brought by the Marshall Islands against the UK, India, and Pakistan, alleging that these latter three states violate their obligations to negotiate the end of nuclear arms race or nuclear disarmament. An equally divided ICJ by the vote of 8-8 in the case between the Marshall Islands and the UK, and by the vote of 9-7 in the case against India and Pakistan, upheld the respondents' preliminary objections because, according to ICJ, it cannot be said that the respondents were aware or could not have been unaware that the Marshall Islands was alleging their breach of these obligations. So in my opinion, you look at the comparison between the Gambia-Myanmar case and these cases, you will see what you call contextual similarities, constatation of claims, largely through multilateral diplomatic forums, with very few supplementary bilateral contacts. And this point has been stressed times and again by the Myanmar's agent in ICJ in December 2019. So the next slide will show that in the merits phase, the Gambia must prove three things. Firstly, that certain Myanmar individuals have committed genocide with intent to destroy the Rohingya. Secondly, such acts of genocide must be attributable to Myanmar under international law of state responsibility. And finally, that Myanmar must have failed to prevent and or punish the act of genocide in question. The ICJ itself has set a very high threshold, ruling that for a pattern of conduct to be accepted as evidence of genocide, it would have to be such that it could only point to the existence of such genocidal intent to destroy a group protected under the Genocide Convention. My book explores in details the rules of procedures and evidence of the ICJ and the ICJ working methods that may somehow come to this kind of arriving at any conclusion whether the Gambia can discharge the burden of proof. However, the next slide will show that unlike the two previous genocide cases, that is, the Bosnian and Croatian genocide cases, in the case brought by the Gambia against Myanmar, this is the first time for the ICJ to determine if individuals are guilty of genocide beyond a reasonable doubt without previous trials or convictions before another competent tribunal. In the other two genocide cases, the ICJ was assisted immensely by the International Criminal Tribunal for the former Yugoslavia's trials of the accused and their convictions. Here is another hurdle. Only after the guilt of an individual has been proved beyond reasonable doubt may the ICJ proceed to determine whether his or her conduct is attributable to Myanmar and whether Myanmar violates the Genocide Convention under the requisite standard of proof for state responsibility, which is different from the proof of beyond reasonable doubt for criminal conviction. Now, the next slide, we will go to the International Criminal Court. Bangladesh is, but Myanmar is not party to the Rome Statute of the ICC, and is most unlikely for the UNSC to refer the Rohingya situation in Myanmar to the ICC prosecutor under Article 13, paragraph B of the Rome Statute, due to the veto power of certain SC members. Two ICC pre-trial chambers have issued rulings on the ICC jurisdiction and authorization for the prosecutor to proceed. In effect, the ICC has jurisdiction if at least one legal element or part of such a crime under the ICC jurisdictions is committed in the state party's territory, such as deportations as crimes against humanity initiated in Myanmar and completed in a state party by virtue of victims crossing the border to the latter state. This rationale may also apply to other crimes, for example, persecution and other inhumane acts as crime against humanity committed after the entry into force of the Rome Statute for that state party. In the next slide, the ICC pre-trial chamber explained how the coverage of the ICC jurisdiction also extends to any other state that may accept the ICC jurisdiction on an ad hoc basis. And the ICC jurisdiction will be exercised after the applicable date of the acceptance of such ad hoc jurisdiction by the ICC. And that for continuous crimes, the ICC prosecutor may extend investigation even when such crimes started before the above date, if the crimes continue after that date. The next slide explains certain difficulties faced by the ICC in practice. Only Africans have been brought before the ICC so far. They are either former high-ranking government officials arrested and surrendered to the ICC after a regime change in their respective countries, or members of paramilitary groups in civil wars whom their countries want punished by the ICC, or who have lost protection from the powers that be. The next slide will explain that. Article 98, paragraph 1 of the ICC statute is a big problem. It provides that the ICC may not proceed with a request for surrender or assistance, which would require the requested state to act inconsistently with its international legal obligations regarding state or diplomatic immunity of a person of the state. Under international law, sitting or what we call incumbent high-ranking officials, such as heads of state or governments and foreign ministers, enjoy personal immunity while they are still in office, whereas other government officials have functional immunity for acts performed on behalf of the government. Since the UNSC will never refer the Rohingya situations to the ICC prosecutor, any immunity enjoyed by Myanmar persons is not implicitly waived by the UNSC. This case is therefore different from the Darfur Sudan situation referred by the SC to the ICC prosecutor, and the ICC has found to be in breach of the Rome Statute those state parties to the Rome Statute that fail to cooperate with the ICC by arresting and surrendering to the ICC President al-Bashir of Sudan, which is not party to the Rome Statute. The next slide will touch upon the legal proceedings in Argentina on the basis of universal jurisdiction. In May last year, Argentina's Federal Criminal Court #1 accepted the complaint lodged by 3 NGOs in November 2019, seeking criminal prosecutions of Myanmar's top military and political leaders for genocide against Rohingya. But the chamber requests more information from the ICC in order to ensure that there will be no duplication of efforts to bring justice to the Rohingya. The next slide look at extensive research published in 2019 in European Journal of International Law, which finds that between the year 1961 and 2017, although there was a huge increase in number of universal jurisdiction trials, most trial defendants are low-level, low-cost defendants. Low-cost mean politically they are not very important. And defendants who were already residing in the prosecuting state. So the next slide will show the picture in Argentina as regards universal jurisdiction. In Argentina itself, the Rohingya case is not the first universal jurisdiction case. In the year 2009, arrest warrants were issued against China's former president, Jiang Zemin, and another high-ranking Chinese officers for crime against humanity committed in China, including genocide and torture of Falun Gong religious sect members. Unfortunately, no arrest has been made against these individuals to date. Arrest warrants were also issued against several Spanish nationals for crimes committed during the Spanish Civil War and General Franco's dictatorship in Spain. But Spanish courts cited Spain's statute of limitations to deny their extradition to Argentina. Complaints were also filed in Argentine courts for crimes in Gaza against Palestinians and in Paraguay and against indigenous people and other victims of human rights violations. Again, no arrest of these accused have been made so far. The next slide also cite two examples in which one should bear in mind. The first one, Human Rights Watch, did not succeed in its complaint before an Argentine federal court to prosecute the Saudi Crown Prince who went to Argentina to attend a G20 summit in November 2000 he was accused by Human Rights Watch of war crimes in Yemen and torture of Saudi citizens. The Argentine government affirmed that the visiting crown prince of Saudi Arabia enjoyed diplomatic immunity, and the crown prince left after the summit before the case could reach the Argentine Supreme Court to rule whether he did have the immunity in question. In March 2018, the Rohingya community in Australia sought leave from the Australian Attorney General to prosecute Daw Aung San Suu Kyi, who was visiting Sydney to attend the ASEAN Australia Summit. However, the Attorney General denied the request on the grounds that, as incumbent Foreign Minister, Daw Aung San Suu Kyi had immunity from criminal prosecution. Next slide. In addition to litigations in the three tiers of courts and tribunals, my book also analyzed the fight against impunity under different complementary mechanisms. Therefore, my book explores unilateral sanctions against Myanmar nationals for their alleged crimes against the Rohingya. I conclude, hopefully convincingly, that such unilateral sanctions are lawful under international law. Since thousands of Rohingya persons now live outside Myanmar, especially in USA, between the year 2008 and December 2018, more than 8,000 Rohingya individuals were admitted as asylum seekers to live permanently in USA. So my book analyzed how they can have recourse to domestic law of these states, which authorize their courts to award compensation to victims of crimes committed abroad. For example, under the US Torture Victim Protection Act of 1991, claims for compensation for torture or extrajudicial killings have been launched against Bolivia's former president and former Minister of Defense, as well as against Sri Lanka's former Minister of Defense and the present incumbent president of Sri Lanka. The plaintiffs under the act may be American or non-American citizens. This is interesting. The next slide will show that claims for compensation may be made against foreign states, not just individuals, for human rights violations. One interesting case, Corvin versus Syria. This one concerned an extrajudicial killing of the Sunday Times journalist Mary Corvin by the Syrian government in violation of US Foreign Sovereign Immunities Act of 1936. The US court in question awarded a default judgment of more than $300 million to the claimants who are relatives of the victim. So the key words there is the relatives of the victims. If the Rohingyas have victims inside Myanmar, but if the relatives live in USA, then they can make use of this act as well. Another interesting case is the compensation paid by the Sudanese government a few months ago in March. In return for the end of US government classifying it as a state sponsor of terrorism, subject to various sanctions regimes, Sudan paid $335 million in settlement to victims and families of hundreds of persons killed and thousands injured by acts of Sudanese agents many years ago. The settlement is paid to American citizens and those persons who became naturalized American citizens after the said attacks. You see, here is another interesting fact. So the next slide. The next slide. According to the independent international fact-finding mission on Myanmar set up by the Human Rights Council, several corporations and executive of companies dealing with Myanmar may be complicit in crimes against the Rohingya. My research have found quite a few interesting precedents for the Rohingya individuals to pursue. Claims against such corporations for civil damages may be possible in certain domestic courts, as in the case brought in Canada by 3 Eritrean workers on behalf of more than 1,000 other workers working at a gold, copper, and zinc mine owned by a Canadian mining company in Eritrea. Criminal liability officers of companies identified by the IFMM may also be possible in certain jurisdictions, as in the Dutch Supreme Court's judgment in the Hoeven case, sentencing the Dutch owner and president of 2 companies in Liberia to 19 years imprisonment for illegal trafficking of weapons and ammunition and complicity in war crimes during the Liberian Civil War. So my last and final slide is entitled Dilemma of Regime Change. Why a dilemma? After regime change, personal immunity of senior government leaders accused of human rights abuse come to an end, and it becomes more realistic to prosecute officials who never have such immunity. This is because functional immunity cannot cover crimes of international concern. The new regime may grant pardons or amnesties to those accused of human rights abuse under the previous regime. However, my book explains that such pardons or amnesties have no direct effect on prosecution in another state, nor can they override the granting state's contrary treaty obligations, nor the obligations owed by that state to victims of the crimes. It is ironic that Daw Aung San Suu Kyi and some other Myanmar persons may be wanted by the ICC and some foreign criminal courts for prosecution. But Daw Aung San Suu Kyi has once again regained the status as the icon of democracy for the majority of the Myanmar population and the West. Can you realistically expect Daw Aung San Suu Kyi to be arrested or surrendered to the ICC or one of the foreign domestic courts? I just leave this question to you to discuss. It seems that for the majority of the international community, the February coup d'etat is the most serious threat to Myanmar. But it seems that regrettably, crimes against Rohingya are not so serious a threat compared to the coup. The ICJ's provisional measures order of 23rd January last year provides a golden opportunity for the government in Myanmar to rebut any accusation or presumption that it harbored no intent to commit genocide against Rohingya. But so far, the reports received from various organizations outside Myanmar, including Human Rights Council, go into one direction. That is, there has been no tangible implementation of the provisional measures. And I will end my presentation at this point by bringing into your attention the first interview by senior General Min Online for any foreign news agency on the 20th of May, that is 11 days ago. We gave an interview to a Chinese language Phoenix television based in Hong Kong. And the interviewer asked him about the Rohingya. And I will read the transcript of the interview for you. He was asked whether Muslims could be allowed back to Rakhine State, where most of them fled the army crackdown in 2017. The senior general says, after Myanmar gained independence in 1948, the census registered the words Bengali, Pakistani, and Chittagong, but never the word Rohingya. Thus, we never accept the Rohingya. And then the interviewer asked again, whether that means vocal international appeals on behalf of Rohingya were to no avail. The senior general nodded his head. So I will end my presentation at this point. Thank you very much for your kind attention.
Thank you, Judge, for a very succinct and insightful summary of a 300-page book. Ambassador Rapp, the floor is yours.
It's a great honor to be with Judge Kriangsak and all of you, and Priya, my good friend, and the others today, and particularly on the occasion of the publication of the judge's book, which is extremely comprehensive. And for those that want to understand the legal tools that are available in this very difficult situation where accountability has been so impossible in the past, I think really need to buy it and review it and have it on the shelf. In my own comment on it, I want to focus on my own experience, not so much my experience as an international prosecutor, which I was at the Rwanda Tribunal and the Sierra Leone Special Court, but my 6 years as U.S. Ambassador at Large from 2009 to 2015, where I worked at kind of the intersection of law and policy, and was frankly always pushing forward accountability and international justice as a way in which we sent a message that would prevent the commission of these crimes. Even as we act against crimes in the past, we send a message to the future. And if we make that credible and increase the risk to actors, we can in fact protect people from these crimes. Obviously, the situation in Myanmar is one that's challenging because there hasn't been accountability, and the message to the regime, largely because of state support from neighbors and from a powerful country, China, and indeed because of a very, very cautious attitude on the part of my government and other Western governments for a fair period of time, have actually meant that the message that's been delivered to the generals is one of impunity. That you can get away with it, and that if too much pressure comes along, you can make a modest opening which maintains your own power over the security services, your own ability to continue to enrich yourself exclusively of the resources of the country, and frankly get away with it. And changing that message is the essential one that we're engaged in now after the fact. The judge's book outlines all of these legal tools that have been deployed, and I really recommend its comprehensiveness, particularly when it gets to the issue of sanctions and the criminal and civil enforcement of them, which sometimes international justice people don't look at, but provide some, I think, very useful tools. I'd note additionally the Lundin case in Sweden, where the prosecutor is potentially going after Lundin Petroleum for crimes in South Sudan that were committed in the early 2000s, and as another example of that tool being used. And the way in which it relates in the US, at least, to the ability to use state-sponsored terrorism, a state sponsor of terrorism, it may open another avenue here if states are willing, and particularly my own, to really actually declare that this government is a state sponsor of terrorism. People haven't proposed that yet, though I was I was interested and shocked by the report from the Human Rights Center, my good friends at Berkeley, working with victims on the ground now who can see the government and the military, which is the government, engaging in terror against the civilian populations, actually killing people randomly in the street and doing horrific things with bodies, et cetera, to terrorize the population. This is terror like Al-Qaeda. And if you declared the government a state sponsor, you'd in fact open it up for civil litigation against the state, as was the case in the Colvin case. There are, of course, other opportunities for civil litigation against corporations, like the Peribah case, dealing in potentially, you can see oil companies potentially exposing themselves in that way in the future, as the bank did in assistance to the Sudan regime when it was under sanctions for genocide in Darfur. So there are some avenues that I think really need to be looked at. But in terms of these legal tools, I think, as I noted earlier, they largely just began to be deployed when we had this horrendous clearance operation in August of 2017, that, as the judge notes, sent 740,000 Rohingya over the border into squalid camps. It was uncertain for when they went over that there would even be the capacity to sustain them, to be frank, given the past experience in that area. But that particular act in regard to the Rohingya did lead to a great international response. And now with the coup d'etat on February 1st, that's become an even wider push against this government and an attempt to use legal tools. That said, we still have the blockage. ASEAN doesn't criticize its neighbors, doesn't have a human rights system. Even Malaysia, with its longtime prime minister, now out of office, but for a long period of time, has seen the Muslims of the world as a particular cause. Their response has been, as the judge noted, to push forward the OIC, not to push forward ASEAN. And I would note, even in the context of Malaysia, when the IIMM was formed by the Human Rights Council and the General Assembly, it was hoped that it would be headquartered in Malaysia, in the neighborhood, and in the end, Malaysia didn't agree. And so it operates from Geneva, which is an awful long ways away from the scene of the crime, and it has limited travel budget to get to and from the neighborhood. So that continued protection by the region is critical, as is, of course, China's certainty of a veto against any effective action in the Security Council, as we've seen, even with China joining with Vietnam and preventing even a statement by the Security Council after the decision of the ICJ unanimously to put provisional measures into effect. The Security Council couldn't even make a statement saying comply Myanmar with those provisional measures. So we see that level of protection. Now, of course, as in the rest of the world, when we've had blockage by great powers, it's been possible to go to the Human Rights Council, and that's a subject that I've been focusing a lot of my attention on, these commissions of inquiry, increasingly moving forward to the idea of mechanisms to gather evidence and to write reports. Well, the commissions write reports, the mechanisms gather evidence, et cetera, and work with civil society and work with authorities that can use it. And I don't want to underestimate the importance of that, though that in the end is something that doesn't have the kind of bite that the Security Council would have. But it can be useful and effective, and can lay the foundation for justice in the future and keep the matter on the agenda and on the focus. But the interesting thing that I wanted to focus on is, frankly, even up until 2017, the international community in Western countries hadn't even ready to go to the Human Rights Council. When I was first ambassador, Tomas Quintana, who's now involved in the Argentine universal jurisdiction case, was then special rapporteur and called for a commission of inquiry for the violations that had occurred in Myanmar, particularly since 1988. And Secretary Clinton, in a moment that didn't actually have clearance, and the rest of the government said this is a good idea. And I went out and began the lobbying campaign around the world to see if we could build a plurality that could prevail on that issue. And we kept working, and we were getting close to 15 or 16 countries. If we had enough abstentions, maybe we could have done it. And then that coincided with the opening, with the Aung San Suu Kyi release, with the military cutting off, the military-controlled government, then Sen's government cutting off the support of the dam. And then we had this opening that led to the election in 2015. And at that point, the signal was, aha, we've accomplished our goal by threatening accountability. We'll ignore, the citizenship law of '82, which excluded the Rohingya. We'll ignore the detentions, the torture, the mass killings and mass sexual violence that occurred during the Four Cuts strategy used by the military in its conflict with the ethnic armies and zones. And so all of that was kind of swept under the rug in return for a situation in which they maintained a veto of legislation, control of everything that they had really controlled before. And so that message of impunity was sent, and this idea that you can trade away any kind of accountability in return for really is not true democracy and not true peace, was the message that was sent. And now we have to avoid sending the same message. I would want to note, as we discuss all of these issues, that we owe it to the victims. We obviously owe it the justice to the victims as our fellow human beings, but we actually owe it to the victims that we've been able to achieve the progress that we have. And it was the activism of the Muslim community in solidarity with their fellow Muslims, the Rohingya, that really did press forward in the OIC and made that unanswerable. And so when my good friend and former colleague at the ICTR, who has since returned to the Rwanda Tribunal as registrar, Bob Tamadou, who was then Minister of Justice of the Gambia, he was chairing this committee. He was the one, and it shows you the great value of these tribunals. People get out there, they learn the law, they build the skills, they work and develop really a sort of a global coalition for justice. And he was in a position to use the position that he held in Gambia, among Islamic countries, and the support that he could gather around the world and to employ one of the best law firms in the world in cases before the ICJ and bring this case forward. And it's an example of what we have benefited from international justice. I think Priya may talk to a greater extent maybe about the ICJ decision, but just again in regard to the victims, of course, they've been highly involved in the process. They were represented in the courtroom when this matter was discussed. They've now been quite engaged with the NUG, and we saw the statement, the National Unity Government, which represents essentially the people who won the election before the February 1st coup. And I note that it's thanks to them that this declaration that was issued yesterday, actually for the first time from that crowd, uses the word Rohingya, and which is it may seem symbolic, but it is important, and talk about the difficult situation of the Rohingya, and talk about relevant stakeholders need to be all engaged, and so I think the one thing that has happened in terms of the victims is that there has been a coming together in a way that there was frankly not before. There was some coming together, but now indeed the recognition that the Tatmadaw is the enemy, and the enemy of all people, including Burma people, is something that I think may have happened here, and that I think will be a legacy. We'll see where it all leads of the military's overreach. They've of course also worked closely with the ICC on this forced deportation case, even though it's only a narrow. They much prefer a narrow forced deportation, not the other crimes as such, including genocide against the Rohingya, not the crimes committed in the rest of the country, but their engagement with the ICC in connection to witnesses, in connection to evidence, without getting into details, because I've been involved in some of it, is really exceptional. And they're the ones that have moved on the Argentine case. Our friend Ton Kin of the Burma Rohingya organization, United Kingdom, together with Rapporteur Quintana, moved forward the case in Argentina, which is now moving again as Argentina has seen that the ICC doesn't have have jurisdiction of the full crime, and therefore they're not duplicating the work of the ICC. So that's all important. And if we have civil litigation in the future, it'll be those individual victims that are going to court that are building the coalitions and the financial support that they need to do that. And so I think that to the extent we've succeeded in this thing, we have to salute that level of activism, but not just activism in terms of putting out press releases and that kind of thing, but activism in terms of bringing the facts, the evidence, et cetera, to bear, and using the legal tools that we hope will send a message. One of the things that's intriguing about the ICJ case, I noticed that the report on provisional measures that the judge discussed is due every 4 months. So there was a report due a week ago on the 23rd of May. Arsalan, one of the attorneys for Foreig, was on a PR program that I engaged in last Thursday, and noted that as of Thursday, the 26th, 3 days later, they had not received notice that the government in place, the Tatmadaw, had filed anything. They wondered if maybe the NUG had, but the court hadn't notified them. But I think the possibility that the NUG might report, and I would certainly encourage them to look for examples that they can find from the social media and elsewhere in which this government has continued to use xenophobic, nationalistic language, has continued sort of conduct that actually increases the risk of genocide, and that's highly relevant. And whatever happens in terms of the merits of the litigation, and we have this jurisdictional issue which may go to the Article 8, Article 9 business, though we don't know for sure, though that issue is provisionally settled. I think that it's important that all of the facts are brought forward for the benefit of the court, and one of the ways in which the NUG can participate and give credibility to that effort is by providing reports that tell what really is happening, instead of the phony message, which was that nothing was being done to prevent the genocide that's been ongoing and continues. So a great honor to be with you, and I look forward to the rest of the discussion.
Thank you.
Thank you, Ambassador Rapp. Dr. Pillai.
Thank you. Well, thank you very much for the invitation to be here today with you all. Thank you to the Bonavero Institute of Human Rights, the Institute for Ethics, Law and Armed Conflict, and the Oxford Transitional Justice Research Group. So, I think it's really a privilege to be here this evening with Judge Kittichaisaree, with Ambassador Rapp, and it's very hard to follow on from two speakers like this, but I will try my best. There are really a lot of issues that the judge's book has delved into in incredible depth and in a lot of detail, as the subject deserves. There are a number of issues, honestly, that are still open that we need to discuss from a legal perspective, from a law and politics perspective, foreign policy perspective, as Ambassador Rapp also referred to. So I think what I will do is I will just touch upon a few of the issues that I think are significant, are important for us to consider, linked to all these international legal developments. I think just on a personal note, I've been working on these issues now for the last few years, and I really would say that in terms of the speed at which some of the legal developments have taken place, it's quite unusual compared to a number of other cases and other instances which we've had protracted proceedings, or we've really had to wait for a very long time. That's not to say that these proceedings are going to now move very fast, or that we are going to get an instant possibility for redress or accountability. But the fact that they have all sort of been set off and in a similar time frame, I think, is also quite significant. And it really is a tribute to the work of a lot of the Rohingya themselves, who've really taken this on and who've sort of followed through and who've really pushed for accountability. So I think that's an important point to note as well. The week of November 2019, the week which, the 11th of November had the filing of the International Court of Justice case. the 13th of November had the universal jurisdiction filing that was made public, and the 14th of November was the pre-trial chamber decision authorizing an investigation at the International Criminal Court. So that was just a microcosm of, I think, a lot of the legal developments. And I think for many of us, it was a matter of sort of keeping track and trying to keep up with a lot of the legal developments and what was going on. And of course, we've also got the independent mechanism. So what I'll do is just briefly look at these four institutions, but I'll also just pull out a few points that I'd like to note from the judges' discussion as well. Just a few things to highlight, and then we can go into a more detailed discussion. I think the one point to keep in mind is in terms of the timing and these legal developments. Essentially, we've got to the point where proceedings are underway. There are a lot of legal steps that are being taken right now. And I think the larger question also for the Rohingya community is, okay, now what? What are the next steps? And what are the possibilities for justice? And what is the guarantee that we will see justice being done? And I think that's a really big question, and that is something that we need to grapple with quite seriously also in terms of what that means for many of the victims, who've placed their faith in a lot of these processes. Having said that, I think just on the International Court of Justice, just to make a few points. One is, the 23rd January order was a unanimous order with, all the judges ad hoc as well, basically agreeing to the fact that certain provisional measures needed to be issued. In terms of the measures that were ordered by the court, of course, one was that the Myanmar government was meant to preserve evidence of potential allegations of genocide as well. That's, one of the six sort of points that the court had decided upon. And of course, as was mentioned before, the constant monitoring, which was meant to be 4 months after the issue of the judgment, which was the 23rd of January, and then every 6 months thereafter. So, we've just come to the anniversary of the fourth report. And there are two things that have happened in the time being. In December, and this sort of went under the radar a little bit, but in December of last year, the International Court of Justice amended its rules of procedures and amended Article 11, essentially setting up a committee of 3 judges who can monitor the implementation of provisional measures. So it may not be directly related to the Rohingya or the Myanmar case, but clearly has an impact and is something that could ensure greater monitoring of Myanmar, and may also have the impact, we'll see with the coup, of sort of cold feet, and we'll see what the Myanmar junta does in terms of its engagement with the ICJ. But I think that's an important point to keep in mind. The second point that I'd make on that is there is a lot of advocacy now on essentially saying that these reports should be made public, that there's really no legal reason in the rules of the court and the statute that would necessitate that these reports are privileged or confidential, and that they should be made available to the other states as well as advocates. So that's again a point of contention, a point of advocacy that a lot of organizations are focusing on as well. The other point that I'd make on the ICJ case is interventions. So we've got Maldives that announced its intention to intervene in February 2020. We've got Canada and the Netherlands, and I think their intervention is also something that we need to focus on and we need to take cognizance of, and to just read out a little bit of the statement. Basically, in September 2020, they announced that they would intervene, saying, this is to assist with complex legal issues and to pay special attention to crimes related to sexual and gender-based violence, including rape. And I think this is something we need to, focus on more, because there have been several instances of conflict-related sexual violence that has been very well documented and is a key part of the atrocities that were committed. So I think it's timely that the intervention by Canada and the Netherlands also focuses on this. Of course, this is also going to raise the questions of what impact it has on the proceedings, and depending on the mode of intervention, we'll have to sort of calculate and see what are the implications as well. The one other point that I would make is the standing of the Gambia. Of course, provisional measures is, it's a decision that is made in the interim. It's not a final decision on a number of the issues, including jurisdiction, including merits. But the focus of the court on, erga omnes partes obligations and the common interest of all states to the Genocide Convention, harking back to the 1951 advisory opinion, where it talked about the fact that the Genocide Convention is in the common interest of all states and not just the specially affected. Of course, this has been by virtue of the fact that in Belgium versus Senegal, of course, linked to the Convention on Torture in 2012, it sort of opened the door. I know that there's going to be a lot of discussion around the application of that case, but what I would also say is that in the case, the judgment did not rely on the potential specially affected status linked to the universal jurisdiction legislation of Belgium, but in fact made the decision based on common interests. So I think that's important to keep in mind as this case progresses. The one other point I'll make on this is that, in the Bosnia versus Serbia case, there were two provisional measures. One in April 1993, the other in September 1993, and then in July 1995, the Srebrenica genocide occurred. So not to speculate or to say that these slightly stronger measures are with the awareness of the history of the previous genocide case, but I think it sort of calls into sort of greater focus the need for implementation of these measures and to ensure that these measures are actually complied with. One point on the ICJ case, we also had a related Facebook litigation in the US, basically by the ICJ, the Council for the Gambia at the ICJ, to adduce evidence from Facebook in the US, given that that was the jurisdiction, to help with the ICJ case and to help with some of the IIMM case collection, information collection as well. So I think, again, important just to keep that in mind, linked to the question of corporate accountability, as it were, or evidence gathering. In terms of the International Criminal Court, the one point that I will make on this case is, the decision to authorize the investigation, 14th of November 2019, which was pretrial chamber 3. While yes, it I think opens the door further than the previous decision, which was based on jurisdiction, which was a September 2018 decision. I do think that while there is reference to obviously deportation, inhumane acts, crimes against humanity, Article 7 crimes, if you look at paragraph 74 of the judgment, I think it leaves the door open a little bit more to the prosecutor to using her ingenuity, using the approach that she has to the case and to the evidence that she's now collecting in the investigation stage to see what are the charges that she wants to bring. And she is not limited or restricted completely by the court saying, it's only those three. So again, it's a bit linked to case strategy and what she chooses to focus on, but I think important to keep that in mind. The other point that I'll make on the International Criminal Court is linked to the question also of command responsibility. Remember that in September, I think last year, there were 2 Tatmadaw soldiers who defected and who have now, made it to The Hague essentially. And while it's speculative, but the question of what is the sort of evidence that they are giving the investigators, and how is that linked to the chain of command? How is that linked to planning as well? The question of genocide, as the judge raised, was there a plan? Was there a concerted plan of action? Whether these 2 soldiers were high enough in the chain of command to know some of this information. Of course, we can only speculate, but it would be interesting to follow and to know what is the result of these 2 defections as well. I think very briefly, and I'm aware of the time as well, just to look at the independent mechanism on Myanmar. I think this is also quite critical when you look at what's happening with the Syria mechanism and universal jurisdiction cases as well. So you've got that initial move for a universal jurisdiction case in Argentina. You've got a mechanism now that has been operational since August 2019 in terms of its terms of reference to collect, consolidate, preserve, and analyze most serious international crimes. And keep in mind, this is from 2011, and the IIMM has also issued a call for evidence of what's been happening linked to the coup, to potential crimes against humanity. Its job is essentially documentation, verifying information, preparing case files, which could be for national courts, regional courts, international courts, different venues. So this is where universal jurisdiction also is linked to what the IIMM is doing. And there could be a greater sort of synthesis between these two realms as well. And I think just on the universal jurisdiction case, as Ambassador Rapp mentioned, a colleague of ours, Tunkin, who heads Brook, has initiated the case. A few weeks ago, we had a very in-depth discussion with Thomas Quintana as well, just in terms of the next stages of this case. As of now, I think we're all waiting to hear, whether it will be given the final green light or not. All indications are pretty good. And I think this is, again, an area that many of us also do want to focus on more, and we're planning to focus on more, which is universal jurisdiction also in the global south, to look at what are the legal hooks in a way that may be available in different jurisdictions that we just don't know enough on, or we don't have enough in-depth research or analysis on. And that's something that a lot of us are working on at this point as well, to expand the scope and to see what are the other legal options and strategies that we can take forward. So I think in conclusion, I would just say, in this case, some legal developments have happened quite fast. I think now it's a matter of balancing some of them and seeing what happens in terms of timing, what comes first. As the judge said, with the ICJ, previous ICJ genocide case, we already had the ICTY that had made decisions even on appeal, imputing responsibility, individual responsibility for genocide. So I think now it's a question of timing between these different legal processes, the possibility also of coordination to a certain extent. Are there overlapping or competing mandates as well? The impact relevance of this to the Rohingya community, what does it mean for them? I mean, we've heard from a lot of our colleagues that, is the implication that they will be able to go home? And I think that's a big question that, is a bit of an elephant in the room, that do these legal processes actually lead down that path? And I think that's something that we need to grapple with quite carefully. And, there was, I think, an initial euphoria. And I think now there are more questions, and I think it's also a question of managing expectations a bit and seeing what happens next, and how long these legal proceedings go. So I'll sort of stop with that. There's still many questions and open discussion points, but yeah, probably we'll get a lot of these questions also in the course of the discussion. So thank you for your attention.
Thank you. Thank you so much, Your Excellency, for your presentation, and Ambassador Rapp and Dr. Pillai for your comments. We're now transitioning to the Q&A part of this webinar. We already have a range of excellent questions in the Q&A box, but just a reminder to the audience that if you do have questions or comments, you can type them at any point in the Q&A function. I'll take the questions in small thematic batches, and as they have not been addressed as specific speakers, I would welcome comments from all three of our panelists. Judge, you mentioned during your presentation that in the book, you seek to address the fight against impunity through different complementary mechanisms. And the first batch of questions by our attendees is related to the identification of specific goals and looking at different ways to address these goals. The first question from this batch is from Luis Peraza, and it is, what will be the formula to keep the military under the civil power for good? Changing the constitution to eliminate the 25% of legislators reserved to the military, limitation of the conditions to be president, winning the ICJ case, cut off all cooperation with the military, or all of these measures taken together? This is question one. The second question is by an attendee who wishes to remain anonymous, and they're looking at the goal of dealing with the Rohingya refugee issue. And they ask whether we can look at Article 25 of the ICCPR and Article 7 of the UN Convention on the Rights of Children. Every child has the right to acquire a nationality. So they wonder whether these rights, if they're implemented, they can help to resolve the various problems related to statelessness and refugee crisis more globally. And the final question, again from Luis Peraza, is whether it is time for ASEAN to create a real commission of human rights or even a regional court to investigate and judge these actions against human and political rights? So leave these 3 questions to our panel.
These questions could be topics for PhD research. So I would put it this way: look at the overall picture, where I think that the Tatmadaw, that is the coup makers, are heading. The UN High Commissioner for Human Rights expressed her concern that what's happening in Myanmar is like what's happening in Syria, that is heading towards civil war. But according to my interpretations of the senior generals, that is Min Aung Hlai's strategy, he exactly followed President Assad of Syria. You know, first you have resistance by the international community, and after a while, once you gain control over the territory and can effectively suppress the opposition, then more and more countries recognize you. Let's just look at what happened in Syria. Assad was boycotted. Syria was suspended in terms of its membership from the Arab League. But now a number of Arab countries try to start reopening the embassy in Syria. And then a few days ago, the general elections returned Assad to his 4th term as president with a vote of 95%. Voting for him, you see, this is realistically, this is what Senior General Min Aung Hlaing is thinking. And with due respect to ASEAN, I don't have much faith in this human rights mechanism. So I don't think that anything about ASEAN can settle the issue, because ASEAN convened a special summit on 24th of last month, inviting General Min Aung Hlaing. He went there and listened. And after he returned to Myanmar, he said, we will not welcome the so-called any ASEAN initiative until there is peace and security in Myanmar, right? And the last questions mentioned about ICCPR refugees. In ASEAN, only 2 states are party to Refugees Convention, Cambodia and the Philippines. Thailand, which has been harboring asylum seekers from Indochina for decades, sometimes with hundreds of thousands from Indochina, as well as Myanmar, is not party to refugee conventions, because according to the Thai policy, it would be too much for the local constituencies to allow these so-called refugees in, to compete with them in terms of livelihood and means of support. So it's just the overall picture that I see, but maybe the other 2 discussions may see differently. Thank you.
Well, if I can jump in, I mean, it's easy to take the approach that the military could potentially kill its way out of this. I deal more on Syria than almost any other issue. You know, and note that the example of Syria is one that frankly destroys what we've tried to accomplish in the last 30 years in terms of accountability in Yugoslavia, Rwanda, and elsewhere. And that unless we're more effective in dealing with the Syrian situation, even now, it becomes much harder to enforce these norms elsewhere. I think we've got to be realistic about that. On the other hand, I don't, whatever kind of, you know, 100% vote a person can gain in a dictatorship, still with more than 100,000 people detained, tens of thousands of people murdered in custody. You now have essentially international sanctions from the EU and from the US and the UK that shut off Syria from the global economy, from countries other than China and Russia that can still help them, but in a limited way. And the ability to reconstruct the country, to rebuild, to actually win the revolution, so to speak, it isn't there. And it certainly shows a bleak prospect for Assad and those that have supported him, to be frank. If that's enough for people to carry things forward, then maybe that's enough. But I think the signal to Syria is, if you're a leader, you really don't want to go down that path. I'm aware of the weakness of these things. I'm always reminded of, one time when Stalin was reprimanded by someone who said, the Pope has denounced what you have said, what you're doing, Marshal Stalin, and he said, well, how many divisions has the Pope? How many divisions has international justice? I mean, how effective are all of these legal tools? And indeed, they're much more effective if we use them early and consistently and raise these issues and prevent ourselves from going into a situation where it's sort of all, where people have crossed the line, where they're committing terror against their own people, where there's no way to really forgive what they've done, then it may become very difficult. But you have to maintain these tools and you have to assure that there will be never, with most of the world, normalization with a regime headed by the Tatmadaw. And that's the rule now and forever. And those of us north and south and need to be with that. And they will pay a price because of what they've done to their own people. And we will use any tool, and we will innovate, and we'll reach a situation where anyone who assists them risks all of their fortunes and all of their assets. And so as long as we do that, as long as it's understood, I think the message is clear. Now, that doesn't indicate that it's going to be pleasant, but I think that has to be what all of this leads to. And I would certainly hope that we could now pull back and move in the direction that people have talked about. And certainly, given the what's happened before, what has to happen again is a more inclusive constitution, a Myanmar with, let's say, 136 ethnic groups, an end to that citizenship law, the return of those refugees, the development of a federal democratic country. That's the goal, and that's what I think the majority of people in Myanmar support today. And will continue to support. It's certainly as they've seen how a military that's even slightly threatened by an election, they were kind of hoping to win because of their nationalistic approach. They thought they were going to get more support than they did, and now they want to steal it and maintain absolutely total control. I think the message is clear that there can't be a compromise in that regard, and the use of all of these tools is about that strategy, and we just have to be tough as nails, and we have to deploy the divisions of the law to stop a genocide, war crimes, and crimes against humanity being committed by this regime.
Can I just jump in on one point? I think on the question of normalization, and the role of ASEAN, since that was one of the questions as well. I just want to also highlight the fact that in the last few days there have been moves to get an arms embargo issued, a General Assembly resolution, and ASEAN states have turned around and said, well, this needs to be by consensus, and that's the only way that this is going to work for us. And so I really do feel that I think the role of ASEAN, where at the beginning of this crisis, I think there was a lot of hope, maybe misguided or not, not really well founded. But I think the focus that ASEAN may be able to alleviate this and help mitigate the situation a little bit, I think seems to be slipping away, and they seem to be in a way normalizing the regime a little bit more. So yeah, I just wanted to note that as well, and maybe we need to focus our energies now a bit differently as well.
Thank you very much to all three of you and to the attendees for these questions. The second batch has to do with some hurdles that were identified during the presentation and in the comments. The first one is by Juliana Guerra. In a scenario in which the ICJ would have jurisdiction over the Gambia v. Myanmar case, do you believe the factual elements could legally qualify as genocide under the Genocide Convention, particularly taking into account the intent to destroy element and the high threshold as to the standard of proof? The second question is by Stuart Manley, and it is asking about the prospect of having the Security Council refer the situation to the ICC, and they draw our attention to the referral in 2005 of the Darfur situation. And they ask whether it is feasible to think about such a referral in the situation of Myanmar. And because I like to take triads of questions that are thematic, I'm going to add one of mine, which has to do with something that Dr. Pillai also mentioned during her comments, which is the use of findings, of fact-finding mechanisms. and the fact that the ICJ relied on the findings of the ICTY, but this was adversarially tested in court-like proceedings. So to what extent do you consider that findings of such fact-finding mechanisms would be used by the court? It did show some willingness to do so in the provisional orders measure, but do you see any obstacles to taking them as they assessed the ICTY faithful? Thank you.
I will answer the first question as follows. You look at the provisional measure orders by the ICJ in January last year. You will see that although the order was approved unanimously, two judges strongly doubt whether even prima facie there was a case for genocide against Rohingya. That is the Chinese Judge Xiu Han King and Judge ad hoc Horst Klees. So with due respect to my colleagues, many of them are my friends in ICJ, I will not venture into answering the question on their behalf. You see, it depends on a very, very individual assessment of the argument, especially the one in which the Myanmar agents stress against and against that. According to the case law, ICTY, ICTR, as well as the two genocide cases decided by the ICJ, if, as in the case of Myanmar, there is a pattern of conduct that may indicate that a genocide is being committed or has been committed, that pattern must be such that it could only point to existence of the specific intent to destroy. You see, I don't know how my colleagues in the ICJ will interpret this. On the second question, yes, the UNSC did refer to the situation in Darfur, Sudan, as well as Libya, to the ICC prosecutor. And then my book also explained the voting patterns in these two instances, why China and Russia did not veto. Because Sudan is a faraway country, it has been a failed state. These two or more SC members did not have any specific interest, and they could, on balance, get along with the majority SC member to refer station to the ICC prosecutor. On the third questions regarding factual findings, my books deals in great details how the ICJ assess evidence and gives a lot of weight to evidence in the reports authorized by international organizations, by independent organizations or entity or neutral entities. And if you look in my view, the evidence found by the IMM set up by the Human Rights Council would be given a very strong weight by the ICJ. And of course, I think I spent at least 6 or 7 pages on all the case law, as well as the way in which ICJ deal with this kind of evidence in the past, although not trial as such. But I think it helps to, and it answers your question. I don't know whether my colleagues will have some additional comments.
Well, let me just jump in as quickly as I can and note that, there are reasonable legal minds that can disagree. And one of the challenges of the Genocide Convention is the difficulty of proving genocidal intent. And many of the worst atrocities committed in the world have not been genocides because they were committed on a political basis, not on an ethnic or religious one. And so we always have to be cautious. One of the reasons I like to see an international convention on the crimes against humanity, so we wouldn't be just limited at the ICJ to this sort of genocide finding. That said, I think having seen evidence that's come out, this whole issue, of course, is it ethnic cleansing? The ICTY said, well, when they just kill people in order to send them over to another part of Bosnia, that's not genocide. If that's what was happening here, that wouldn't be a genocide. On the other hand, we have evidence of code black orders being issued in a variety of areas, which mean kill them all. We have mining at the borders to keep people from crossing over. I mean, we've got other sort of acts that are diminishing verse. There is, I think it's crossed the threshold of a genocide. And even if it doesn't, the ICJ is well advised to be in the case because of the dangers of genocide, because of the hate speech and the xenophobic language that in fact increases the risk of a genocide. So I think it's good that it's there, and I think that when the evidence is all before the court, they'll find that a genocide has been committed and should find so. Regarding the fact-finding mission, fantastic work by the two fact-finding missions. I think that when you deal with a fact-finding mission that doesn't get down to specific individual criminal responsibility, which is a necessary element, I think, before we get up to state responsibility, it's difficult to rely on a fact-finding mission on that. On the other hand, when you deal with international crimes, and including at the ICC, a key fact is the contextual elements, the existence of a widespread or systematic attack, the existence of an organized plan or policy, even aspects of intent. And on that big picture, I think the way in which these fact-finding missions accumulate the evidence and put it together and analyze it can really help overcome that hurdle. But when you get to the facts, I think the important thing will be the kind of evidence that is being brought out by survivors, that's being shared with the IIM, that's being vetted and verified, and that we won't have a judicial determination on that unless we get it, but that'll be on forced deportation at the ICC. I think that it's going to be necessary for the ICJ to look at that evidence and evaluate it according to the burden of proof. But they'll benefit enormously from these UN mechanisms in doing that.
I think maybe just to jump in very briefly on the fact-finding point. I mean, I think internally within the statute and the rules of the ICJ, there's a lot of scope. So, you look at articles 48, 50, you look at rules 57, 58, 60, 61. The ICJ has a great amount of scope to actually do some of this fact-finding itself. And, also to make the point that the IIMM made a statement, I think, again, last September about sharing information with the ICJ as well. So, maybe this is a chance for the ICJ to actually do a bit more in-depth fact-finding and assessment without the reliance purely of another international court that has made these determinations before.
Thank you very much. I'm mindful of time, but I insist on having had 3 rounds of comments. So the final batch of questions has to do with our engagement, or the international community's engagement with authorities in Myanmar. The first question is by Bran Chang. What are the possibilities for the international community working with the National Unity Government and the National League for Democracy to get them to promise to accept the Rohingya people as Myanmar citizens and to prosecute or extradite perpetrators of atrocity crimes in exchange for international support and legitimacy? There's a second question by Andrew Carswell. He would appreciate hearing from the panelists regarding the UN's recognition of the credentials of the Union of Myanmar. Will the National Unity Government be represented at the General Assembly, the Human Rights Committee, and ultimately the International Court of Justice? And as we're approaching the end of the time, I would also like to ask our panelists for final comments, final words before we close this seminar.
So since at least 2 of your questions mentioned about the National Unity Government, so I just would like to touch a bit on the NUG. There was some complaint that the NUG, which is supposed to be multi-ethnic, does not include Rohingya. So the Rohingya community complains that, you're supposed to be federal, all-inclusive, but why leave it out, right? So this is something that the NUG has to remedy. I will not touch upon the NUG credential in UNSC, etc., or in the UNGA, etc. But Ambassador Rapp yesterday sent me a copy of the NUG statement, saying that it is willing to continue with the case in the ICJ. But as Priya pointed out, at least the NUG could at least monitor the implementation of the provisional measures on behalf of the international community to show its goodwill and transparency. I also have some question regarding the NUG's position that it is actively considering ad hoc acceptance of the ICC jurisdiction in the case of the so-called suppression of peaceful demonstrators by the Tatmadaw after the coup d'etat. So my point is, I wonder whether the NUG also knows that Article 12, paragraph 1 and 3, when read together, means that when you accept the ICC jurisdiction on an ad hoc basis, you cannot confine the jurisdiction to specific incident. You accept jurisdiction, say in Myanmar, for crimes against humanity. So crimes against humanity covers also crimes against Rohingya, right? Although the charges against Myanmar individuals can confine the scope of crimes against humanity to say the Tatmadaw's use of force against peaceful demonstrators. I know that my interpretation was correct, is correct, because almost 10 years ago, Thailand also considered accepting the ICC jurisdiction on an ad hoc basis to allow the new governments to let in the ICC to prosecute the previous government for the so-called extrajudicial killing of peaceful demonstrators. So I contact the office ICC prosecutor for information and confirmation, and it was confirmed that no, you cannot confine the extent jurisdiction to specific incident. You accept jurisdiction for the whole territory for the crimes under ICC jurisdiction, war crime, genocide, crime against humanity, or aggression. So I wonder if the NUG knows about these implications. They are willing to take a risk that some of their members, including Daw Aung San Suu Kyi, might be implicated in one of the crimes against Rohingya. Thank you.
Let me jump in on that. They're fascinating issues to deal with. On the representation issue, the ambassador to the UN, the permanent rep, of course, is spoken against the Tatmadaw and against the coup, and remains in place in New York. And I think it's important that countries support him. And certainly the precedent in the UN has been that when you have these illegal changes of government and where their diplomats that are accredited are supporting the prior government, the legitimate one, you don't replace those. You fight very hard for them to stay in place. And I think the UN and other states that want to see a change here need to stick with that position. And certainly I think in terms of the vote in the General Assembly, if there were one, we saw even on the Rohingya issue, the vote was like 145 to 12 or something to support the IIM's creation, et cetera. I think there is support broadly within the membership to prevent the Tatmadaw from being seated. That said, I was very disappointed that the HRC allowed a representative of the Tatmadaw to speak at the session in March, and that was a mistake. But from here on out, I think we've got to be really tough on that. On the 12.3 issue, it's a fascinating one. The judge is right, except I think to the note they can put a date on the declaration, which is something that happened in Ukraine. But once you have the date, then everything thereafter goes before the court. That said, I think the ICC is reluctant to get involved in competing governments. Morsi's movement, duly elected president of Egypt, he attempted to refer what Sisi was doing, who ran an illegal coup d'etat, to the ICC, and the ICC wouldn't get involved in that question. Of course, we've got the situation in Palestine, which is a little different because that dealt with the question of whether Palestine is a state. And there wasn't really any question that if there was a state, it was represented and led by the Palestinian Authority in Ramallah. There wasn't a dispute on that. So that's a little different. I'm not sure that the 12.3 thing would work. It would be intriguing given the fact that that you do have this legitimate government with all its representatives. It's not exactly the same situation as Morsi, but I'm not sure that the ICC will go there. I think they'll continue their efforts in terms of the forced deportation, and as allowed, as Priya said, by the decisions of the pretrial chamber, broadening that to look at the related crimes that were all engaged in that process, in which at least 740,000 Rohingya were forced over the border beginning in August of 2017.
I think for me, just in a way, by way of sort of concluding remarks, is this, we've focused now a lot on the Feb 1st coup and what's happening correctly as well, I think. But I think now in these few months, I think the focus is shifting back again to the Rohingya and to questions of justice and accountability as it relates to the MUG as well. So I think, the Rohingya question and justice accountability for them is becoming a bit of a lightning rod as well for sort of credibility and legitimacy as well. And I think it's becoming a crucial key question. And it's becoming more sort of discussed now. And I think that could affect the way that the NUG is also viewed. So I think it's important that we're having this discussion as well, with the coup, but to focus back on the Rohingya as well, and to see what are the options and what are the possibilities.
Thank you very much. Thank you all of you for this rich and thought-provoking and important discussion that we had today. Unfortunately, our time has run out. It was an absolute privilege to co-host this seminar. Thank you, Dr. Pillai and Ambassador Rapp, for these excellent remarks. And thank you to Justice Kittichaisaree, whose work has inspired and continues to inspire generations of international lawyers who want to work in the area of accountability for atrocity crimes and human rights violations more generally. Our warmest congratulations on your new book, and we very much look forward to seeing you in Oxford soon, when circumstances permit. A big thank you to the Bonavero Institute for Human Rights and ELAC. It's always a pleasure to collaborate with you. A big thank you to my wonderful colleague, Gayatri, with whom we co-convene the OTGR. And finally, of course, a thank you to our attendees for the excellent engagement, for your questions and comments. You made this discussion really rich and engaging. From Oxford, we wish you a lovely morning, afternoon, or evening, and we hope to see you soon.
Thank you.
Thank you so much.
Thank you very much. Great. Have a good day.